Good evening.
Evening.
Good evening.
Sorry for reaching late. The rain kind of got me. I feel like every time I have class with y'all, it's raining. Look at that. Saturday, it is rain. We're on a whole different day and it's raining.
Blessings.
And let's call it that. All right, just give me 2 minutes. All right, everyone. Inga, I did carry everyone's exam to work today. Rushing on my left it, but Inga, I do have the notes from yours. So we could go over it after class. I took everyone's thing to work today so I could have scanned it and sent it to you. and rushing out, I left it. But Inga had your notes somewhere separate. So if you're available, probably a few minutes, we could go over it and I could let you know.
Okay, thank you.
All right. All right, so today I wanted to go over, we've done quite a few stuff with IBCs. So I wanted to go over the Companies Act, companies and the difference. I think that it seems as if some of you are just more familiar with Companies Act, if I'm not mistaken. And I'm going to judge based off of the answers on the exam. And I just want to point out a few differences because there are, and I feel that in the exam, some persons were answering as if certain things apply to both. So I just wanted to sort out some stuff. All right, now with the Companies Act, who can tell me how many subscribers are required, the minimum?
Two?
Inge, if you're talking, you're muted because your screen's lit up.
Can you hear me?
I can hear you now. If you was talking all that time, I couldn't hear anything.
Okay, sorry, I said two?
Yes, two. What about requirements on shareholding? I know that some of you were saying the minimum was 2 directors. But in the Companies Act, you have to have at least two members. With the IBC Act, with the IBCs, you can have one shareholder. So for example, Inga, you could own a company straight out by yourself. With the Companies Act, there should be at least 2 listed. Even though if it's still owned by one person, you have to have at least 2 persons listed. One of those persons can hold the share in a nominee capacity. Now, what is a nominee capacity? What do we understand by that?
My understanding is a natural person or a business elected to represent the company as a shareholder or director. They're nominated and the company would pay a fee for this service.
Correct. Now, okay, Marcia, since you touched on it, what would you see that comes along with someone or a company that comes along with holding a share in a nominee capacity?
Based on the question, I'm a bit unclear. When you say
Okay.
come along with it, you mean what requirements would there be?
Okay. All right. Let's do an example. So
Okay.
let's just say Inga wanted you to hold the share for her, right?
Right.
So you would put your name down on the statement or the share register.
Mm-hmm.
So when it's time to, let's say, when it's time to. All right, no. Let me break it down. Even though your name is on the share register, how would we know that it's really Inga you holding it for?
So we would have internal forms for the ultimate beneficial owner, and we would also have a declaration of ownership that would be
That's what I'm
signed.
looking for right there.
Okay, it will be signed by the UBO rather than the nominee.
Declaration. And so in the declaration, you would have the name of the company.
The
You would
date
have, mm-hmm,
and the name of the actual beneficial owner.
the name, yes, so you would have the name of the person or company that you're actually holding the share for.
Right,
You'll be giving up any control or rights to the share, recognizing that it is actually not for Marcia, but it's for Inga.
yes.
So Inga, have you all come across any like that?
I haven't.
What about you, Desmond?
I do know that we do have like nominee companies that would hold shares for the owner.
All right, and sometimes it doesn't have to be a company. It could be an individual holding it for someone else. Again, like Marcia could hold it for Inga. Maybe I'll do have a lot more cases than you think you have with that, Inga and Desmond. All right, now with a Companies Act, another difference is Companies Act requires you to have annual general meetings at least once a year. Then the annual general meeting, sometimes what typically goes in it, it would state who was at the meeting. So let's just say if it's Marcia, Inga, and Desmond own a company, if you're there, it will state that you were there. But if Marcia, Desmond, and Inga isn't there, let's just say Desmond wasn't available to go to the meeting. There can be something called a proxy. Are we familiar with what a proxy is?
Yes.
What's a proxy, Desmond?
Proxy is a form you would fill out delegating your whatever rights you have to someone else.
That's not really delegating your rights, but you're authorizing someone
Yeah.
to represent you.
Yeah. Yeah, like they would stand in position for you since you're unable to be there.
Because yes, if you're unable to be there. So if Desmond wasn't there and Abigail had to fill in for Desmond, it would say, Abigail McKenzie, proxy for Desmond being Fran Fowler. What goes in it as well is typically with the Companies Act company in the articles, your directors are elected every year or until the term is up. So if you have an annual general meeting every year, you have to stipulate within your meeting who the directors will be for the following term or for the following year. Not all articles, well, most articles for the CACs state that officers are elected by directors. So there's no need for you to state who the officers are in an AGM unless the articles state that the officers are also elected by members. You would also speak to the articles of your financials. In most cases, some mention it, I talk on top of my head, and some mention it, but like stating that they didn't discuss it. I noticed that a lot of companies don't discuss it there, but we would discuss it in, let's just say, other meetings. But that's something that should be put inside there. So from your AGM, where the members were present, they talked about who the directors are. You have to, within 14 days, you have something called an annual statement. So it's 14 days after your annual general meeting. And what goes on your statement would be the particulars that comes from your AGM. Your AGM also talks about any other business. So anything that you would like to discuss, maybe shares, maybe not, goes inside there. So your statement has particulars of your company on what happened in the AGM. So for example, let's just say we had an AGM on June 30th. Our statement would be made up to which day?
Would it be the date of the meeting?
Sorry, go again with the
Not-
question.
I said if we had an AGM on June 30th, our statement is 14 days after. So what date would the statement be made up to?
July 13th. Sorry, to be July 14th.
Yeah, July 14th. So Inga, just for clarification, your AGM is held on one date and your annual statement, or they call it, some call it annual. Well, let me not mix it up. Let me put annual statement. Your annual statement would be 14 days after the date of your annual general meeting, your AGM. On your statement, you would list out who the members are, how many shares they're holding, question, if, let's just say Inga and Marcia are shareholders and Desmond is holding a share in a nominee capacity for Marcia, who goes on the statement?
Desmond.
Desmond. Does everyone understand that? Or why does
Yes.
Desmond go on, Abigail?
Because he's the nominee shareholder. So what is required is that you send in the name of the shareholder, not the ultimate beneficial owner.
Correct. Also on the statement, you would say how many shares the company has, how many was issued, the number of the company, if any changes in the shareholding took place from the last filed document. You would put who your directors and your officers are, and then it's typically signed by the secretary. You can get someone else to sign, but it's typically the secretary. And that is filed at the registry. That is a requirement to be filed at the registry. annually. If you ever try and get a good standing and that's not filed, they will deny you the good standing for a Companies Act company. We've had cases where, well, I've come across cases where everything was filed, let's say, except for a statement from 1998. They did not give us the good standing. Another statutory requirement to be filed is a declaration of ownership. Now, the declaration of ownership states whether the company is 60% owned by Bahamians or 60% owned by non-Bahamians.
I have a question going
That
back to the AGM.
Yeah,
Okay, so the AGM is typically takes place on or around the date of incorporation each year, right?
it does. A lot of people do that just because to make it easier.
Okay, because sometimes it doesn't necessarily happen like that. Like some
No,
people,
it doesn't necessarily
their
happen.
incorporation will be in August and they'll have an AGM in December.
Yes. Sometimes I think that happened too, because you have, I think it's about 18 months from you
Yeah. Mhm.
are incorporated to have your AGM. Now, what is interesting though is that, let's just say you do have your AGM in August, right?
Mhm.
We're in July now. So if you always had your AGMs in August, your statement was filed between August and September, and
Right.
you asked for a good standing, you'll get that if you filed completely up until last year.
Right, yeah. Yeah, I know that much, yeah.
Now with the declaration is also important because it helps you to know the fees of the company. Companies owned by Bahamians under the Companies Act pay $350 yearly. Companies that are 60% or more owned by non-Bahamians pay $1,000 annually. That is a big difference. So if in doubt of what fee to pay, you can always go on who owns the company.
I have another question with shareholders. So
Mhm.
if foreigners own the majority, so no, I just want to know if we actually have to get central bank's approval for non-Bahamians to be majority shareholders.
No,
For
that
CAC?
comes in if like they want to, if they're opening up a like a bank account.
Okay.
Okay, for example, with a regular company, you have there's two kind of sides to the regular company. You have the foreign registration, and if you all have
Yeah, we do
had the opportunity to deal with any of those.
that.
So for example, all foreign registrations, they pay $1,000. Once you see a company as a foreign registration, you don't have to wonder if it's $350 or $1,000.
Right.
But for exchange control purposes, it's if they're opening up a bank account, if they, I think if they want to own land, they have to go through BIA, Bahamas Investment Authority, and then also exchange control. Hold on one moment for me, please. Okay. So in terms of central bank approval, approval is typically required for companies that are designated resident and require USD account. So USD bank account. Approval is also required when a Bahamian holds shares in trust for a foreigner. And when a foreigner owns land or dealing with in local currency. And you should always seek prior approval before trying to do any kind of operation. So Abigail's answer question, if someone is coming in, and then typically too, if a foreigner has a local company, maybe they're doing something local here, then that's central bank approval. Hello?
Yeah, okay. Okay, I understand, thanks.
All right. And then what happens to then whenever, if you do have to get central bank approval, whenever your shares are transferred, if there's a change in, let's say, signatories with the company, you'll have to seek approval or apply for validation if you're going after things have already changed. But with that, central bank also, it has a checklist when you're doing applications on their site. So it makes it kind of straightforward on what to on what you have to give in, and that goes for IBCs as well. Everyone following or everyone dead from work?
Both.
We follow it.
Okay. Yeah, I had a rough day today too. So all right, so back to the CAC. So yearly, you have to pay your annual fees. You have to file your declaration of ownership, which is the 60% Bahamian or owned, or 60% Bahamian not owned by Bahamians. You have to have your annual general meetings, and you have to file your statements. Now, another difference is with the IBC. The IBC is when we change directors, you would go back and you would make the filing with the registry. With a Companies Act company, you're required to send a notice of change. So it's not really like the table register. You would send a notice notifying them that, hey, directorship went from Abigail to Makita. And this is now the register. This is now the directors of the company, Makita, Marcia, Ingo. So you file a notice for the Companies Act company. Once it's the notice is filed when there's a period between the AGM and the actual change. So for example, let's say the AGM isn't until August or the end of August, and we make a change today in who our directors are, we're gonna file a notice to the registry. And not wait until August to effectuate the change. And why would we do that? Anybody? So we would file the notice, notify the registry, because we are required to do what?
Make them aware of any changes.
Yes, and then, any type of resolutions going into the registry. So for example, if we made a change today, but we wait until August, and it changed from Abigail to myself. But at the beginning, or let's just say, yeah, the beginning of August, Abigail sends in a resolution. Who's the registry gonna see as a director on the company? Me or Abigail?
You,
No, they can have, if we don't notify them of the change, they're still gonna see you, even though it's me now.
oh, okay, yeah.
And then really and truly, that resolution wouldn't be valid because you're no longer a director.
Director, okay.
So it's important to notify them as the changes happen. Another difference between the IBC and the CAC is that the IBC will be struck off the register after 1 year of non-payment. With the companies, our company, you can get up to about maybe
20
20
years.
years. I see now they started to start striking people off. I don't know what's going on.
Yeah, I had a company, they did it after 16 years.
I think they're just trying to clean up.
Yeah, that could be it.
But that's a very long time to not have to pay fees. And what happens too is that you're supposed to pay your fees every year, file your statements. You're supposed to be, if you're operating a business, get your business licenses renewed. But I think they're tightening up because a lot of persons are still operating their businesses without doing any of these things.
Yeah, that's probably because they don't have to request anything of the registry.
But now, since they tighten up with the business licenses, you need a good standing to request your business license. They're recouping their monies now and getting their filings done. Another difference is after 5 years in the IBC Act, you have to restore through the courts if you've been struck off for 5 years. But according to the CAC Act, you have 20 years. Now, if that means the same as, but it says 20 years to go through the courts. So you can look at it as almost 40 years. So even though the Companies Act is a bit more tedious to maintain than the IBC, it does have its advantages. And I guess too, for locals, probably not being able to to pay yearly. If you miss 2 years, you just go and you pay for your 2 years. You don't have penalties and you don't have the restoration after a year. But if that company is struck off, if it is eventually struck off, then the same applies with the $600 within 24 months and $1,000 after 24 months for restoration. Inga, Desmond following?
Yes,
Yes.
How has it been for you guys?
Oh, well, they found, well, I shouldn't say they found, we have 2 associates dealing with that, so I'm not really getting the feel for it. Desmond will probably touch on it more than me.
Oh, so you're not getting the opportunity to actually do the work.
Yes.
But even if they have associates, that still should be a separate function. I mean, I feel it should be a
They
separate
did.
function.
They got thrown into that. It wasn't voluntary, they got thrown there.
And you don't have the opportunity to like shadow or nothing.
Yeah, shadow them because they need help. So they kind of feeling their way through as well, like they're learning.
Mm. Well, the best way is to do it and you learn. And some mistakes you don't want to repeat, so you definitely learn. An advantage too of the companies, our company for local, is that okay, for example, they came across a company, it has been struck off the register, but they were for 25 years. So that $350 for the 25 years was almost $9,000. It's like 8,000 high. But you could imagine if for 25 years you're a foreigner and you have to pay 1,000, that's $25,000 off the top. So again, it has its slight advantages and disadvantages. All right, so since we say we was following Inga, I want you to give me 2 differences between the companies, our company and IBC.
With the IBC, when you change your directors, you must update the registry. And with the CAC, you can file a notice regarding the change of directors. And the notice is filed when the AGM or the period of change or something like that. Is that correct?
No. So you file, okay, so example, if your AGM isn't until August, but you change your directors today, you would want to file your notice before August, before your AGM. But let's just say if you change directors today and your AGM was tomorrow, you can wait until your AGM and just put an effective date. So when you file your statement, your directors will be on your statement. But if there's a period of time between your annual general meeting and then, after your annual general meeting is 2 weeks after for your statement, and that's a lengthy period of time. So you have one difference there. So give me a next. Hold on, sorry. Did I clarify that for you?
Kind of.
You muted.
Sorry. I said, yes, kind of you did. So you clarified the
So-
one with the CAC. So with the IBC, that was correct.
Yeah,
Okay,
the IBC, you file your registers.
right. And with the CAC companies, you file a notice,
You file a notice.
right? And that's when the IBC will be struck off the register after 1 year of non-payment. And the CAC can be struck up to 20 years.
After 20 years, yeah.
And the next one is with the IBC. If it's been struck after 5 years, you have to apply to the court. And with the CAC is after 20 years, then you can apply to the court to have it restored.
Correct.
Okay,
And another difference is that the CAC does not give you penalty and the IBC does. So remember, we went through the 10% penalty, 50% penalty. The CAC does not give you penalty, but if you are struck off, you have to pay a restoration fee. All right, Desmond, can you give me two differences?
With the CAC, you have to file statements every year, and with the IBC, you only file a new register when there's a change in the directors.
Now, hold on, Desmond.
Well, there's a change in the officers of the company.
Desmond. Inga just told me that.
Oh, she said that one? Okay. With the CAC, you need at least 2 shareholders. With the IBC, you only really need 1.
Okay. And what was your first one?
With the CAC, you have to make annual filings of the annual statement. And with the IBC, you only file a new register if there's a change in the directors and officers of the company.
So you can say that you file a statement every year, but you don't have to file, you don't have statements to file with IBC. It's
The filings, you don't have to have yearly filings
no,
as it relates to the register.
no. All right, Shanrisa, can you give me two differences? All right, Marcia, can you give me two differences?
With the CAC companies, you have to you have to have an annual general meeting at least once a year. With an IBC, you don't. And the second one is you're not required to file an annual declaration of the percentage of Bahamian ownership as it relates to shares for IBCs, but you do with companies.
Correct. Abigail?
They didn't already cover all?
Mm-mm.
No? I can't think of any other right now. I thought they covered all.
So let's see. We said annual statement,
Mm-hmm,
AGM, notice,
mm-hmm,
the declaration of ownership,
yeah.
I think it's Marcia, you talked about the members.
No, Desmond mentioned that you only need one member versus IBC.
And we talked about struck off, period.
Mhm.
Yeah, there's only 6 stuff, Abigail.
Well. Um. Well, I don't think we mentioned it, but with CAC, when you reserve a name, it has to have limited or LTD at the end of it. But with
Mhm.
IBCs, you have a variations of suffixes to use.
Mhm.
And well, I honestly can't think of another. Give me a topic and then I'll say what it is.
Let me write this. Um, no, that. Well, I guess that fall under AGM. Hold on, I drawing a blank. I think I talk a bit too much. Hold on. So we talked about the annuals, the AGMs.
Mhm.
No, we talked about the members.
Yeah.
I guess with the members comes along with the proxies and stuff, but or the declaration. But that could be the same with the IBCs. We talked about the AGM. We talked about the statements. Declaration of ownership, the notice where you would send it to the registry if there's a change in the directors. Now, sorry, with the notice, it's with the directors only. You really have to send the notice if there's a change prior to. All right, we talk about the struck off. Okay, one other thing you could probably mention, I did mention it at the end. Fees.
Oh, the fact that the CAC doesn't have any penalties and IBC incurs penalty?
Correct.
Okay.
And then another difference topic touching on the fees is that you know that a CAC is owned, well, should happen is that when it's owned by Bahamians, the fees are $350. Non-Bahamians,
It's 1,000.
1,000. And the difference with that with the IBC is what? When are the fees $350?
Share capital is 50,000 or less.
And when is it 1,000?
If it's 50,000 or more, it's $1,000.
Over 50,000. Yeah.
Yeah, 50,000 or more, yeah.
All right, so we okay with the differences?
Yes, thanks.
Yes.
Yes.
Well, actually, were you going to touch on the dissolution differences between IBC and CAC?
We could touch it. So, hold on, before we get there. Well, I wasn't gonna touch that tonight because the next class thought it was gonna be on dissolutions on both, because we didn't do dissolutions when we did the IBC. Because we have one more class after this. Unless you wanna go through both.
It don't matter. If it was set for
We can just
next
probably
week,
go.
next class is fine.
Hmm?
I mean, if it was set for next class, then that's fine. But how long we gonna be in this class?
This class, I wasn't taking it too long, only because it's after, it's after work. I don't want to drag nobody out until 9:30. You know,
I have a
some of us
question
have
when you're
families.
done.
Hmm?
I have a question when you're done.
Okay. Also for Saturday's class, I want to do the class at 9:30 if possible.
No, ma'am, I'll be in church.
Okay. I have to see how I can figure this out then. I forgot I have a wedding on Saturday.
I mean, it could be through the week again. That's fine with me.
If it's, let me see. Let me look. If it's through the week. It would probably have to be like Tuesday again. Which is August 1st. Is everyone okay with that?
That's fine with me.
That's fine.
Yes.
Sure.
I have a question. Are you going to tell us what's going to be on the exam or which date is the exam?
Yeah, so the date wouldn't be the holiday weekend. It would be after that. So it can be through the week or it could be on the Saturday.
I'll need to take the
What
exam
is-
on a Saturday.
What day is the holiday? Hold on. Right. Oh, I'm in the wrong calendar, sorry. So the holiday is on the 7th. All right, so it could be the 12th then.
I travel that week. So I won't be here
Which day?
on the 10th.
You
All
can
right,
let
we can
Abby
come with
take
something
hers
like-
early. She won't allow me to cheat.
What?
You could let Abby
If
take
I
hers
give her-
early.
She'd have to have a completely different exam then.
Woof.
As long as it's multiple choice and not all that writing. Jesus.
Hold on, the writing was intentional and to have you thinking.
Yeah, I could think while typing. I prefer that. But child, that writing that had my hand hurting.
Oh, so you're saying you rather type it out?
Right.
I mean, if y'all want to, we could I mean, if some of y'all have your laptops and that's what you want to do.
Now, wait a minute.
I don't know, but we have to I guess come together collectively on the date. And Abigail, hold on, how long you gone for like that week?
Yeah. So I'll return on the 21st.
Oh wow, hold on. That's a real vacation.
Yes, well deserved.
I believe you.
Second that.
What you say, Marcia?
I second that. She does deserve it.
Aw,
I actually sometimes I'm scared to go for that long because
the work you get when you come back.
Yeah, that's a
yeah,
real
it's
flair for real.
sometimes it's feel like it's not worth it.
Yeah.
No, it's definitely worth it.
Oh, yes.
All right.
It is.
So are we saying it will be the 12th?
I looking, I guess if
I
everyone else
might
could do
not
it the
be
12th,
able to do it that date either.
okay. So. What? Hold on now. All right, Abigail, you back on the see. I didn't mean that. I don't want to drag the class till the 26th. All right, let's do that then. We could do it on the 26th, and by that time, I'll give you material to study.
Okay, the
Okay.
In between
26th
that.
should be fine.
Because I just have a few more things I have to put in for your study material. So that should be fine. Because I was just trying to put in examples. And I guess, the visual make it all make a little bit more sense as well. All right, so can we agree to the 26th?
Yes.
Yes,
that's-
Okay. All right, so Abigail, since you want to touch, we could touch on some dissolution. See, but I was gonna give you a lot to read tonight. This. Hold on. You all have your material?
yes.
All right. Let me see. Let me see what I have here. I want you to go to the IBC Act. I think it's section 134. I don't have any. Let's see. Does everyone have it?
Yes.
Okay. I'm calling numbers up my head. Just make sure it's 134.
I think it goes up as early as 132 or 131.
Yeah. All right, so let's go there. All right. So we look at 131. It says that the company shall commence to wind up and dissolve by resolution of directors upon the expiration of such time as may be described in its memorandum or articles for its existence. Now, what do we take that to mean?
I think we could take it to mean that the amount of time it'll take to be wound up is dependent on the date set in the M&As after the resolution.
Okay,
No?
anyone else? Let's check it. Now, that was Marcia, right?
Yes.
So if you're there, I want you to read it one more time.
Okay. A company shall commence to wind up and dissolve by a resolution of directors upon the expiration of such time as may be prescribed in its memorandum or articles for its existence.
Or what's existence?
I guess the length of time that it has been in existence.
Now remember, sometimes when you incorporate companies, they're incorporated for a reason, for a specific reason,
Right.
or a specific period. But here usually that doesn't really is the case.
Apply. Okay.
All
But
right.
I do see your point, meaning like for executive entities, although this is for IBCs, they would have like a more definite time frame or purpose, right?
You know, like sometimes you have companies that are incorporated, for example, just to own a ship
Right.
that carrying something from China to the Bahamas.
Mhm.
It might do 2 or 3 trips and then that's about it, and then they just wind up the company because it's like has no point after that.
Okay.
All right, a company that has never issued shares may voluntarily commence to wind up and dissolve by resolution of directors. Okay. Subject to any limitations or provisions to the contrary in its memorandum or articles. A company that has previously issued shares may voluntarily commence to wind up and dissolve by resolution of members or by resolution of directors. So what's the difference between those two?
Should there be no limitations in the M&As, the company can be wound up voluntarily either by the members or directors unanimous resolution.
And then 132.1 was saying what?
Oh, a company who has never issued shares may be voluntarily wound up and dissolved by a director's resolution, obviously because there are no members.
And then the second one speaks to
If there aren't any
Yeah.
limitations, in the
Mhm.
M&As, where shares
All
have
right.
been issued.
So when winding up, again, what do we look at when we doing anything with these companies?
M&As.
We're looking at the M&As. And if there's something in the M&As, if there's something not in the M&As, for example, some companies have their own precedents with the M&As once it's guided by the act. If it's not inside there, we should always look to the act itself. All right, 133.1. A resolution of members or directors to voluntarily wind up and dissolve a company shall also appoint a liquidator for the purpose of winding up the affairs of the company and distributing its property. What does that mean?
The resolution from either the members or directors to liquidate a company must be accompanied by an actual liquidator to commence the winding up process,
As it says,
to distribute its property, because you have to sell all assets or transfer all assets out of the company's ownership prior to winding up.
your assets should be at 0. Why should it be at 0? Why should all go?
Come on, classmates, I've been carrying you through this dissolution.
Plus, the company won't exist anymore.
Exactly. So let's just say a company did not distribute its assets and it dissolved. All right, so let's say let me find an example. If a company did not distribute its assets and it's dissolved, but let's just say, for example, the asset was worth $1 million. They didn't transfer from the company name to Inga. Inga could touch that $1 million asset.
Nope.
No, she cannot. Nobody can touch the asset. So then you'd have to do a restoration. How? If you're already dissolved, how can you get back on the register? Restoration through the courts, which will be probably a hefty bill. All right, if there is no liquidator acting in the case of a voluntary winding up, the court may, on the application of a contributory, appoint a liquidator, and the court may, on due case shown, remove any liquidator and appoint another liquidator to act in the matter of a voluntary wind up. What that mean? Besides Marcia.
Exactly.
All right, so what it's saying is that if there's no liquidator, the court may appoint a liquidator upon application. And if case may be, remove any liquidator and appoint another one. All right, so far, what do we understand? When you wanna wind up voluntarily or winding up, what do we need so far?
Resolution
Mhm.
from directors, if you don't have shares issued. Resolution from the shareholders or the members, if you do. You have to appoint a liquidator. And you have to distribute your assets. Before,
All right, so,
before you do wind down, you have to distribute the assets.
right, so upon let's just say appointing a liquidator. What do you think we need from the liquidator? Just like what we need from the directors.
The consent to act.
Yes, the consent to act. Because I could go and I could put down Abigail name as my liquidator and I take that to the registry. And Abigail don't know nothing. So the registry or whoever tries to contact the liquidator, because I could go, well, we didn't reach there yet. But you know what, we wait till we reach there. We wait till we reach there. Yes, a consent to act. What else do you think we could possibly get, though, if we're going to liquidate somebody's company? How do we protect ourselves?
Well, you need something, some kind of statement of asset or liability saying that you do not have any more assets in the company. So that it's clear on our end that you do not have any assets and the company is good to wind up.
And who would sign that?
The director.
All right. So let's just say you are appointed as the liquidator. You consent to act as the liquidator. What do you need to protect yourself? What do you think you need to protect yourself? Remember, a liquidator comes with much responsibility. Once the company's been handed over to the liquidator, they control what's going on. There's no longer Abby on this company. The liquidator has control. What should the liquidator provide for themselves to save, not to save, to protect themselves?
An affidavit of solvency.
And an indemnity.
Indemnity, yeah.
All right. So let's go on. Upon the commencement of a winding up and dissolution required under section 131 or permitted under section 132, the directors may authorize a liquidator by a resolution of directors to carry on the business of the company. Only if the liquidator determines that to do so. Hold on, one moment, please. All right, sorry about that. So it says, A, authorize the liquidator by resolution of directors to carry on the business of the company only if the liquidator determines that to do so would be necessary or in the best interest of the creditors or members of the company. And B, determine to rescind the articles of dissolution only as permitted under section 140. Well, we haven't reached there. So again, upon the commencement of the winding up and dissolution, required under section 131, permitted under section 132, the directors may authorize the liquidator by resolution of directors to carry on the business of a company. To carry on the business of a company only if the liquidator determines that to do so would be necessary in the best interest of the creditors or members of the company. What do we get from that?
I suppose if an issue arises, the liquidator would want to would want to say the director needs to handle the operations of that business until it's settled before they take over and dissolve the company.
And what kind of interest it said the liquidator should determine what is what?
What's
Go
best for
again,
In the
question?
best, in the best interest of the creditors or the members.
Oh, yeah.
Or B, determined to rescind the articles of dissolution only as permitted at section 140. So let's go down to 140 and see what that says. Has anyone ever rescinded a dissolution? All right, so 141 says, in the case of a winding up and dissolution permitted under the section 132, a company may, prior to submitting to the registrar a notice specified in section 1386, rescind the articles of dissolution by a resolution of directors in the case of winding up and dissolution under section 1321, or a resolution of members or resolution of directors in the case may be in the case of, as the case may be, in the case of winding up the dissolution under section 132. Two, a copy of a resolution referred to in the subsection 1 shall be submitted to the registrar, who shall retain and register it with the registrar. So before we read number 3, section 141. In the case of the winding up and dissolution permitted under section 132, a company may, prior to submitting to the registrar a notice specified in section 1386, rescind the articles of dissolution. So, all right, so 1386, before we get that, speaks to the liquidator statement. When we reach up, you'll see what it talks about. But it's basically saying that, the company has done its distributions and that they can finalize their liquidation. Has anyone ever rescinded? No?
Yeah, I did. This is a little while ago though. Yeah, but I did one.
I rescinded before as well, and they charged the same $200 as to file
Exactly.
it.
Mm-hmm. And you have to
So
put it in the papers as well.
just be sure. All right, so what section is on? All right, 135. A liquidator shall, upon the appointment in accordance with this part, and upon the commencement of a winding up and dissolution, proceed to identify all assets of the company, identify all creditors and claimants against the company, to pay or provide for payment of or to discharge all claims, debts, liabilities, and obligations of the company, to distribute any surplus assets of the company to the members in accordance with the memorandum and articles, to prepare a cause or to be prepared a statement of account in respect of the actions and transactions of the liquidator, and to send a copy of the statement of account to members if required by the plan of the dissolution required in section 138. So what is that saying in a nutshell about the liquidator?
It's saying that the liquidator has to identify all of the assets of the companies and also take care of all the affairs like outstanding bills. Make sure that the company is completely solvent and then distribute any remaining assets according to the M&As, and then prepare a statement with all of the transactions, sending a copy to the members.
Proving.
Right. Proving what was done.
All right, so let's go to 2. A transfer including a prior transfer described in section 11.2 of all substantially of all or substantially of all the assets of a company incorporated under this act for the benefit of the creditors and members of the company is sufficient to satisfy the requirements of subsection 1C and D. So that's talking about a different section 11, which we didn't go over. And then subsection 1C and D, and I'm assuming it's C and D in here. So it says, it's talking about transfers or prior transfers. Are included. But should be sufficient to satisfy the requirements, and 1C is talking about to pay and provide for payment of 2, discharge all claims, debts, and liabilities, and to distribute any surplus and assets. All right, 136. In order to perform the duties imposed on him under section 135, a liquidator, so the section will be just stated and Marcia just summarized. A liquidator has all the powers of the company and that are not reserved to the members under this act or in the memorandum of articles, including but not limited to the power to take custody of the assets of the company in connection therewith, to register any property of the company in the name of the liquidator or that of his nominee, to sell any assets of the company at public auction or by private sale without any notice, to collect the debts and assets due or belonging to the company. Are we looking at the powers of the liquidator?
Yes, we are.
Powerful. To borrow money from any person for any purpose that will facilitate the winding up and dissolution of the company, and to pledge or mortgage any property of the company as security for any such borrowing. To negotiate, compromise, or settle any claim, debt, liability, or obligation of the company. To prosecute and defend in the name of the company or in the name of the liquidator, or otherwise any action or legal proceedings. To retain counsel and attorneys, accountants, and other advisors, and appoint agents. To carry on the business of the company if the liquidator has received authorization to do so in the plan of dissolution or by resolution of the directors permitted under section 134. As the liquidator may determine to be necessary to be in the best interest of the creditors or the members of the company. To execute any contract, agreement, or other instrument in the name of the company or in the name of the liquidator. And to make any distribution in money or in any other property or partly in each and in any other or partly in each and if in any other property, to allot the person or an individual interest therein or equal in equal or unequal proportions. Now, do we see how powerful the liquidator's position is?
Yeah, reminds me of the
Yes.
Securities Commission.
What? So once we appoint a liquidator, please be sure your liquidators are reliable. Oh, of good standard. All right, notwithstanding subsection 1H, a liquidator shall not, without the permission of the court, carry on for a period of excess of 2 years the business of a company that is being wound up and dissolved under this act. So you see how long that could go on for? All right, we're gonna look at 137, power of liquidators and contributories in voluntary winding up to apply to the court. So where a company is being wound up voluntarily, the liquidators or any contributory of the company may apply to the court to determine any question arising in the matter of such winding up, or to exercise as respects to the enforcing of courts, or in respect of any other matter, all of the powers which the court may exercise if the company were being wound up by the court, and the court is satisfied that the determination of such question or the required exercise power will be just and beneficial, may accede wholly and partially to such application on such terms and subject to such conditions as the court thinks fit, or it may make such other order, interlocutor, or decree, or such application as the court thinks just. So in a nutshell, what is that saying? So it's saying that when in doubt, the liquidator has a question, and if the court sees fit, they can what?
Apply to the courts for clarity.
And if they decide to answer you, they will. So 138, the directors of a company required under section 131 are proposing under section 132 to wind up and dissolve the company shall approve a plan of dissolution. So what does the plan of dissolution contain? It says here a statement of the reason for winding up and dissolving, a statement that the company is and will continue to be able to discharge or pay or provide for the payment of all claims, debts, liabilities, and obligations in full. A statement that the winding up will commence on the date when the articles of dissolution are submitted to the registrar, or on such date subsequent thereto, not exceeding 30 days, as it's stated in the articles of dissolution. A statement that the estimated time required to wind up and dissolve the company. A statement as to whether the liquidator is authorized to carry on the business of the company if the liquidator determines that to do so would be necessary on the best interest of the creditors and members of the company. A statement on the name of the address of each person to be appointed as liquidator and the remuneration proposed to be paid each liquidator. And a statement to whether the liquidator is required to send all members a statement of account prepared or cause to be prepared by the liquidator in respect of his actions and transactions. The winding up and dissolution is being affected in the case, before we go into that, what do we get from that part? Your plan has to have what? Your plan has to state your plan. Why are you winding up? That although you're winding up, if anybody come after you with any claims or debts, you could pay them. Same when you will, that your commencement date is when your resolutions are filed or your articles are filed with the registrar. And so you'll have 30 days from now. Tell them how long you think it'll take to wind up. The powers of the liquidator. You should give them the name of your liquidator and how much you paying them. And if the liquidator has to send what we just talked about, the members, the statement of the account. So has anyone seen a plan, a plan of dissolution?
Yes.
No?
Yes, I have.
And so the things we call off, it sounds familiar from that, eh?
Yes, very familiar, yeah.
All right, let me see if I should go through this. Right, if winding up and dissolution is being affected in the case of section 132.2 is applicable, the plan of dissolution shall be authorized by a resolution of members or a resolution of directors, as the case may be, and the holders of the outstanding shares of the class of series and of a class of series of shares and entitled to vote on the plan of dissolution as a class of series or series only if the memorandum or article so provide. If a meeting of members is to be held, notice of the meeting accompanied by a copy of the plan of dissolution shall be given to each member, whether or not entitled to vote on the plan of the dissolution. So that's saying whether you have shares that are voting or not, you still have to get a copy of it, of the plan. If it is proposed to obtain the written consent of members, a copy of the plan of dissolution shall be given to each member, whether or not entitled to consent to the plan of dissolution. So because you're a member, and even though you might be minority, you still have the right to know of the company or the plan of the company for shutting down. All right, let me see. Maybe we don't have to go through some of these. After approval of the plan of dissolution by directors, and if required by members in accordance with subsection 2, the articles of dissolution shall be executed by the company and shall contain the plan of dissolution and the manner of which the plan of dissolution was authorized. So that's why the articles accompany the plan. And what must the articles contain?
I think it kind of repeats the plan.
Yes, it is accompanied with it. All right, you're on 138.4. Articles of dissolution shall be submitted to the registrar, who shall retain and register them in the register, and within 30 days immediately following the date on which the articles of dissolution are submitted, to the registrar, the company shall cause to be published in the Gazette a publication of general circulation in the Bahamas and in a publication of general circulation in the country or place where the company has its principal office, a notice stating that the company is in dissolution, the commencement date of the dissolution, the name and address of the liquidator. So this is where this is called commencement notice, basically. 138.4. So the commencement notice happens after you filed your plan, your articles, your resolutions to the registry. So let's do the filings. Typically, we file either the resolution of members or the resolution of directors, along with the articles and the plan. So let's just say if we were to file no, let's go back. Why would it be the resolution, the plan, and the articles? Y'all falling asleep on me.
Is it because that's what the act requires?
As I said, I say.
Right, so that's why we're gonna have all three of those documents for the registrar. To
And
commence it.
remember that it says, after the approval of a plan of dissolution by the directors, if required by all members in accordance with the subsection, articles of dissolution shall be executed by the company and shall contain the plan regardless, and the manner of which the dissolution was authorized. All right. So after we file those, it says within 30 days immediately following the date of which following the date on which the articles of dissolution are submitted to the registrar, the company shall cause to be published in the Gazette in publication a general circulation of the Bahamas. So has anyone seen a commencement notice before?
Yes,
Now this is saying, yeah, so within 30 days immediately. It has to have notice that the company is going into liquidation, when the commencement day was, and the name and address of the liquidator. Why do we think these three things have to be on this notice that is going into the paper?
one for any creditors that the liquidators may not have been aware of, so they can come after whatever is owed to them.
Yeah, so it's to basically put the public on notice that, hey, this company is going into liquidation. This was the commencement date. We already read up that it takes about 30 days. So you have this amount of period of time, and this is who you're gonna contact if you have any queries on the liquidation of this company. So that's why we have to give a notice out. Right, a winding up and dissolution commences on the date the articles of dissolution are registered by the registrar, or on such date subsequent thereto, not exceeding 30 days as it is stated in the articles of dissolution. So we just talked about those 30 days. So 138.6. A liquidator shall, upon completion of a winding up and dissolution, submit to the registrar a notice that the winding up and dissolution has been completed, and upon receiving the notice, the registrar shall A, strike the company off the register, and B, issue a certificate of dissolution under his hand and seal certifying that the company has been dissolved. So only after the liquidator statement is filed that you can receive the certificate of dissolution. The liquidator statement is usually accompanied by proof that the commencement notice was filed. So when you file your notice, when you publish your notice in the paper, you would want to clip it out and have that as proof. So when you send your statement down to the registry, you would send that with your liquidator statement to show them that you did that you did publish within the 30 days from your commencement notice. Now, from what I know, you can typically rescind a resolution up until you file that liquidator statement. If you file a liquidator statement, it's dealio. So please keep that in mind. Your liquidator statement, the date that is filed, that is usually the same date that would be on your certificate of dissolution. The only way that I know of that won't be the same date is, for example, if you filed your liquidator statement today, and we know that the registry works slow. They might come back 2 weeks from now and say, oh, but your fees was missing for this year. When you pay your fee, just like the good standing, that'll be the date on your certificate. We're going to go to 7, where a registrar issues a certificate of dissolution under his hand and seal certifying that the company has been dissolved. A, the certificate shall be prima facie evidence of compliance with all requirements of this act in respect of dissolution. And B, the dissolution of the company is effective from the date of the issue of the certificate. So let's just say you get your certificate August 15th, but your certificate saying July 28th. Your issue date is July 28th, not the date that you got the certificate. So even though you got it August 15th, 2 weeks afterwards, your company was dissolved from effective July 28th. Immediately following the issue of a registrar of a certificate of dissolution under subsection 6, the liquidator shall cause to be published in the Gazette, in a publication of general circulation in the Bahamas, and in a publication of general circulation in the country, or a place where the company has its principal office, a notice that the company has been dissolved and has been struck off the register. So what is this? This is what we call our final notice. Once you get your certificate of dissolution, you will go back to the papers again and you'll just give them a notice. You'll give them a notice stating that the company has been wound up. You will also file that with the registry once it's published. And that will be basically your, as far as it goes with the registry, with your winding up. All right, so let's see. Sorry, I'm missing skip. It said effect of voluntary winding up. Whenever a company is wound up voluntarily, all transfers of shares except transfers made to or with the sanction of the liquidators or alteration in the status of a member or alteration in the status of the members of the company taking place after the commencement of such winding up are void. So read that again. Whenever a company is wound up voluntarily, all transfers of shares except transfers made to or with the sanction of the liquidators or alteration in the status of the members of the company taking place after the commencement of such winding up or void. So again, you have to go to your liquidator, basically. Because if you already commenced, how are you transferring shares? $140, the rescission and winding up of a company and dissolution. I think we read this one. It says in the case of a winding up and dissolution permitted under section 132, a company may prior submitting to the registrar a notice specified in section 138(6) rescind the articles of dissolution by a resolution of directors in the case of the winding up and dissolution under section 132(1), and B, a resolution of the members or resolution of directors in the case, as the case may be, in the case of winding up and dissolution of section 132(2). So what is the difference between those two right there? So remember when we first started off at 131, it talked about 132(1). I believe that spoke about if you're gonna dissolve and you have nothing issued, no shares issued, compared to if you're gonna dissolve and you have something issued. Remember?
Yeah. Because the
that's
resolution
speaking
would be signed by the directors if no shares were issued, but by the
Mhm.
shareholders if shares were issued.
Mm-hmm. So 140 speaking to that, if you're trying to rescind, and it says you can only rescind prior to submitting your liquidator's statement. Or a copy of the resolution referred to in subsection 1 shall be submitted to the registrar, who shall retain and register it in the register, register it in the register. So if you want to rescind prior to submitting the statement, then you will do so and they will retain it and register it in the register. So within 30 days, immediately following the date on which the resolution referred to in subsection 1 has been submitted to the registrar, the company shall cause a notice that the company has rescinded its intention to wind up and dissolve to be published in the Gazette, in the publication in the general circulation in the Bahamas, and in the publication of general circulation in the country, or in place where the company has its principal office. Now, once you've made your filings and then you go and you publish in the newspaper, this company going into liquidation. But now you rescind them, it's just saying the same thing. You have to go back now and tell the world, okay, we ain't liquidating no more. We understand that piece? So just how you would say, hey, I go into Bimini next week. You change your mind, you'll go back and say, hey, never mind, I ain't going no more. Because let's just say you had published it somebody had seen it, say, oh no, these people owe me money. So now they taking whatever precautions they gotta take to try and get their money from you, but now you actually rescinding it, so you have to let persons know, be aware. Or even touch one more thing on 141. The directors, or as in the case may be, the members of a company that is required under section 131 or permitted under section 132 to wind up and dissolve at the same time of the passing of the resolution to wind up and dissolve the company, have reason to believe that the company will not be able to pay or provide for the payment of discharge of all claims, debts, liabilities, and obligations of the company in full, or the liquidator, as after his appointment, has reason to believe, then the directors, the members, or the liquidator, as the case may be, shall immediately give notice to the fact to the registrar. So what that's saying? If you go into if you're winding up the company and you know you can't make any payments, you have to give notice to the registry. You all still with me? Because I feel like I just talking to myself.
Yeah, I'm still here.
Mayor,
I'm here.
Here. Winding up, but here.
Exactly.
I could feel it. All right. Let me give y'all something for next week. Are we saying next week? Hold on. Next week, Tuesday? All right. So for your companies act, I want you to read the part with the winding up. And then we'll do a difference.
Okay.
So that's
218 of the Companies Act.
yeah. Waiting. All right, another point I'd like to make out, and only breeze past it before. Application to dissolve to the registry is $200. Any questions?
No, but I do have a comment.
Mhm.
I think it's important for the liquidator to also let the client know that if they do rescind, they're still required to pay whatever the liquidator charges them and the $200 to liquidate.
Yeah, that $200 was then gone.
Right.
That was- And even with the liquidator, see, all that comes into your agreements too.
Yeah.
So, as a liquidator, that's why I said you have to have certain stuff in place when like Marcia was talking about. Marcia was talking about when I told you the indemnity. You said something before that.
I honestly can't remember right now.
Not Marcia, sorry, no, Abigail. Abigail mentioned something.
Regarding what?
Oh, solvency,
Yeah, the
declaration of
affidavit of
solvency.
solvency. Yeah,
Yeah, so again, and then your agreements, you have to have your agreements, and your agreements should have certain things in place. So you gotta think, but all that is liquidator. All right, so we'll read the company's doc next week. So everyone is agreeing on the Tuesday after the holiday.
Yes.
Yes.
Okay.
hold on, which
Oh,
Tuesday after the holiday? What day that is?
You mean the,
Oh, sure, start after the
the
holiday. That's next
first,
week
No,
Tuesday.
that's just next week Tuesday.
And I hear saying yes.
Yeah.
So next week Tuesday would be the 1st of August.
Yeah, sorry. I don't know. I thought that was after. I thought the 31st was the holiday. Sorry. I don't know.
No,
It's getting late.
Sorry.
yeah. The holiday is actually Monday on the 7th.
Yes, and I did say that earlier. I don't, sorry, I don't know what I was thinking.
I mean, it's 8:37, so anything, I mean, you're excused.
Yeah, that's why I don't like doing classes in the evenings, it's kind of mental strain, but. So we'll do the comparison next week, and I wanted to do something else. I know we touched slightly on the continuation, but I wanted to go back over that. And then we could go more into exchange control too.
Okay, I'm looking forward to the exchange control for sure.
Yeah, we could go more into that. I know, before I forget, remember, everything now is boss. You liquidate, update boss.
Yeah.
All right, so I guess next week, Tuesday then, same time.
Okay, thank you. Have a great evening all.
Good evening, all.
All right,
Right.
so.
All right.